het zou wel vrij uniek zijn om zo'n promotie te doen zonder de kandidaat.
In accordance with the customs of this university, I will open this ceremony with a prayer. Spiritus Sancti Gratia, illuminet sensus et corda nostra. Please be seated. A very warm welcome to the public defense of the thesis of Mr. Wadaya, dealing with the dark past, the prospect of the settlement of the 1965-1966 events in Indonesia. I would like to specifically welcome our guests from outside of Nijmegen who have joined us via Zoom to attend this ceremony. Thank you for participating in today's ceremony. This is not an ordinary ceremony in many respects. Unfortunately, Mr. Wadaya is not able to physically join us here in Nijmegen, but will conduct his defense online from Indonesia. And also not all members of the doctoral examination board are physically present here in Nijmegen today and will participate in the debate online. Thank you all for taking the effort to participate in today's debate. And I now give the floor to the candidate for the degree of doctor, Mr. Wadaya.
With the permissions of the Councils of Deans and in order to obtain the degree of doctor from Radboud University Nijmegen, I would like to defend in public my doctoral degree, my doctoral thesis. I would like to defend in public my doctoral thesis entitled Dealing with Dark Past, the prospect to settle the 1965-66 events in Indonesia. On September the 30th, 1965, 6 army generals and 1 adjutant were kidnapped and killed by the Presidential Guard Cakrabirawa. Suharto, a mid-rank generals at the time who were not targeted by the troops, accused the Indonesian Communist Party as the sole mastermind of the events. Shortly after the kidnappings, Suharto accused the communists as behind the killings and the sole mastermind of the killings. Suharto took over power from Sukarno a year later and became president of the Republic of Indonesia from 1967 to 1998. Reports and studies state different numbers of victims during the violence. CIA and Department of States, for example, estimated the death toll between 250,000 to 500,000 people. Meanwhile, Sarwo Edi Wibowo, the mine executor which led his operation in Central and Java, claimed that his troops had eliminated no less than 3 million people. The government never admitted the crimes and even tried to hide it from the knowledge of the public even until today, nearly 2 decades after the fall of Suharto. On the other hand, civil society organizations, victims groups, and pro-democracy activists tried to bring the case to the attention of international communities. A series of examinations held by the International People Tribunal, or IPT 1965, in The Hague in the year of 2015 was probably the most monumental example of this approach. In 2012, the National Human Rights Commission submitted a full report to the Attorney General Office following a preliminary investigation carried out by the commissions over the alleged human rights abuses during the periods which the commissions called the 1965-1966 events. Beside the killings, the commission found other forms of violence such as forced labor, extrajudicial detention, torture, slavery, and rapes. One of the most crucial points of the report is the acknowledgement that there is adequate initial evidence to believe that crimes against humanity have taken place from September 1965 until at least 1978. I believe that an in-depth academic examination of the suggested follow-up of the preliminary investigations of the 1965-1966 events, as recommended by the National Human Rights Commission, is relevant and also important to be done. The information obtained from the investigation would be needed once the Indonesian government considers to implement the recommendations of the Commission to put an end to the humanitarian problem. Three questions that in my dissertations. First is, what is the most adequate and effective legal mechanism to deal with the perpetrators of crimes against humanity, as far as the 1965-66 events can be qualified as such if such crimes were to reoccur in the future, considering relevant obligations under international human rights law and within the limits of national or Indonesian law. Does the current international and national legal system allow for the investigations and prosecution toward the 1965-66 events as recommended by the National Human Rights Commission in its report? And the third, can the mechanism of Truth and Reconciliation Commission, or TRC, as recommended by the NHRC, can be applied for the settlement of the events? My research found that the obligation to respect and protect human rights has become an inherent part of the Indonesian legal system since the establishment in 1945. The founding fathers of Indonesia have set up a framework to protect the human rights and freedoms of the people, which is embedded in the preambles of the Constitution and manifested at various levels of legislation. The ratifications of the ICCPR complements the commitment to the adherence of human rights at the international level. As to the protection from human rights, as to the protection from gross violations of human rights, especially crimes against humanity, the dissertation shows that Indonesia already has the legal instruments needed to investigate and prosecute in case such crime as took place in 1965-66 events would ever happen again. The presence of Law Number 26, year of 2000, of the Human Rights Court in the Indonesian legal system can be viewed as a proof of the seriousness of Indonesia to confront the issue of gross violations of human rights. Together with crimes of genocide, crimes against humanity are punishable acts under jurisdictions of the Republic of Indonesia. Despite the country's bitter experience with the crimes, Indonesia is not a state party of the Rome Statute, an international treaty that established the International Criminal Court to try the perpetrators of gross violations of human rights, including crimes against humanity. Consequently, it is not possible to bring those responsible for the crimes to the ICC should serious human rights offenses are taking place in Indonesia, and the country cannot, or is genuinely unwilling to do so. However, the fact that Indonesia is not a state party to the ICC does not necessarily mean that such crimes are not punishable within its jurisdiction. Together with crimes of genocide, crimes against humanity are categorized as gross violations of human rights and are sanctioned with severe punishment by Law Number 26, 2000. My research, however, found that the law does not define crucial elements such as widespread, systematic, or intention in its provision. The law also opens the possibility to use Law Number 8 of 1981 on criminal procedure law, a piece of legislation that was designed to deal with ordinary crimes and in many ways does not fit with the international standards. What is worse, crucial provisions related to command responsibility were formulated in a way that makes it very difficult to bring military commanders or those who held effective military control to justice. So, revisions of the Human Rights Court law is necessary so that it can function optimally to sanction the perpetrators of gross violations of human rights. Regarding the settlement of the 1965-66 events through a court mechanism, my dissertation shows that there is no legal barrier to bring the perpetrators of crimes to justice. Although the events took place long before the promulgation of the Human Rights Court law, the prosecution of those responsible for crimes is a legal action that is possible. Article 43, Section 1 of the Human Rights Court law have a way to retroactively apply the provisions of Human Rights Court law on cases of past abuses like 1965-66 events. However, the research also shows that despite the extraordinary work of this commission, the achievement of justice still seems to be far from satisfactory due to the unwillingness of the government to settle the case. There is a strong impression that the office is running a time-buying strategy by continuously maintaining that the report is incomplete. No one, even until today, has been prosecuted to account for the crimes, although certain military reports believed to be responsible for crimes explicitly mentioned in the report of the NHRC. Indeed, settlement through an ad hoc human rights tribunal is not the only available option to resolve the case. But the decree of the People's Consultative Assembly number 6, AMPR 2000 on the national unity and law number 26, year of 2000, mandated the establishment of Truth and Reconciliation Commission as an alternative forum to solve the past gross human rights abuse, especially the case that occurred during the New Order regime. The settlement through a TRC, however, requires a TRC law as a legal basis for the establishment of the commission. While this condition was initially fulfilled with the promulgations of Law number 27 of 2004 on Truth and Reconciliation Commission, my research found that the settlement of 1965-66 events through a Truth Commission is not possible, at least at the time of writing of my dissertation, and even until today when I present this, due to the 2007 decisions of the Constitutional Court, which declared Law number 27 of 2004 unconstitutional and without binding legal force. Apart from the possibility to settle the 1965-66 event by improving the provisions of Law number 26 of 2000 in the Human Rights Court and creating a new law on the TRC, this dissertation concludes that the decree of the Provisional People's Consultative Assembly number 25, MPRS 1966, will be a legal barrier for the settlement of the events, be it through a mechanism, be it through a court mechanism, or through a truth commission. The decree that labeled the PKI, or the Indonesian Communist Party, as traitors of the nation has become a reference of many state policies related to the 1965-66 events. This legal instrument will put the victims and their families always in an unequal position, especially when dealing with the perpetrators in truth-seeking and reconciliation processes, as well as an ad hoc human rights court. Therefore, there is no other solution for this problem other than to revoke the decree so that the negative stigma that sticks to the victims will not hinder the searching for truth, both through court and non-court mechanism. This will not be an easy task, although theoretically it can be done.
Mr. Wadaya, sorry to interrupt you, Mr. Wadaya. May I respectfully ask you to come to a conclusion?
I return to the floor.
Thank you very much for that introduction, that summary of your thesis. We will now proceed with the defense of your dissertation. And it is my pleasure to give the floor to Professor Adam, Professor Adam is Research Professor of Political History and Political History of Indonesia at the Indonesian Institute of Sciences. Professor Adam, a very warm welcome and thank you for participating in today's ceremony. The floor is yours.
Thank you. Thank you very much, Mr. Chairman. Dear candidate, I am grateful to be invited as a member of the jury for Manunggal Wardaya dissertation examination. The dissertation on the prospect for the settlement of the 1965-66 cases in Indonesia from a legal perspective was well done. But I have a correction on the excerpt from Executive Summary of Komnas HAM report on the serious human rights violation of 1965-66 regarding Buru Island. Wardaya quoted from the executive summary published by Komnas HAM, page 62-63, halaman 62-63 in the dissertation. However, the two paragraphs regarding Buru Island are wrong because they relate to events that occur in Central Java and North Sumatra. Now, my question. President Joko Widodo administration has 2 years remaining. Do you think the current government can solve past problem or part of it? In such a short time, what can be prioritized? Which is the priority? Says the revision of the Human Rights Code law so that Komnas HAM report can be processed by the AGO, the Attorney General Office. Second, the establishment of the TRC in Indonesia. Is it possible in 2 years? My second question related with one is, Indonesia has conducted a serious human rights trial in East Timor case in 2001. None of the perpetrators were convicted in appellate court. In other part, Timor-Leste had organized the CAVR in 2004. In order to maintain good relation between the two countries, the Indonesian Timor-Leste Truth and Friendship Commission, Komisi Kebenaran dan Persahabatan Indonesia Timor-Leste, was formed in 2005. This commission revealed the truth, stipulating that the state is the perpetrator of gross human rights violation, but no one has been prosecuted. No perpetrator has been prosecuted. Can this model of Indonesian Timor-Leste Commission of Truth and Friendship be used as a model of truth and reconciliation commission that will be formed in Indonesia? That's my question. Thank you.
Thank you, Professor Adam. First of all, I would like to thank for the correction from my dissertation about Buru Island. Secondly, I would like to address your questions. You have two questions. First of all, about the terms of current President Joko Widodo is going to finish his presidency in 2 years. And you asked me whether there is opportunity or he will just let the case go or gone. Well, I have at least two speculations for this. Because the current President Joko Widodo still have 2 years, then he can use the remaining years to just do whatever he wants without considering the public pressure, because we know that in Indonesia, this issue is very sensitive. Maybe before, he considered too much about this issue because it can be a boomerang like that. So it can be good. It can be stick to the Constitution, stick to the law number 26, and bring the case to justice. But also because he has 2 remaining years to office, in his office, then he can just will not do anything because this is his second term. He will not be bring by the political party for the third presidency because it's not possible under the constitution. So he can just let go. He just can let the case unresolved. If I should mention which one is the most likely will occur, then I will say maybe the second possibilities that will prevail. And you asked the second question. You asked about the model for the East Timor Truth and Reconciliation Commission, also the trial of the held at the time. Well, coincidentally, I was in Melbourne at the time, and I listened to the speech of Ramos Horta at the time. Ramos Horta is, if I'm not mistaken, currently like vice president or still in high positions in East Timor. I remember precisely Ramos Horta said that East Timor in Indonesia will uphold the friendship, maintaining peace, and that's why they established Komisi Kebenaran and Persahabatan, or Truth and Commission and Friendship Commission. Truth and Friendship Commissions. This shows that a truth commissions cannot be separated from political considerations. East Timor is located in, if you see the archipelago of Indonesia, it's a tiny state in Indonesia, surrounded by Indonesian territory. I think political consideration dominate the establishment of Komisi Kebenaran and Persahabatan in East Timor. Some readings on transitional justice that I read state that transitional justice is unique. So one country may be different to one another. Of course, the impacts in East Timor, the enormous impact also we can find in Indonesia about the 1965-66 events. And but at least, because in East Timor they have that Truth and Reconciliation Commission, they have compiled a human rights violations, which entitled Cegai, if I'm not mistaken, or No More. They compiled the relatively detailed and so many human rights violations in East Timor. At least that has been done by the commissions. So maybe we don't really have to copy the commissions like in East Timor, but good stories or the best practice there with the establishment of the commissions, and that the fact that they have investigate the case, and then they held truth-telling, and they compiled stories from families, from victims, survivors, then I think Indonesia should copy that. We have already actually, and I've written in my dissertations about the International People's Tribunal. But again, the International People's Tribunal is initiative from the civil society. So it is not from the state, while human rights always demand the role of the state and the responsibilities of the state. So, Honored Professor Adam, that's I can answer all your questions. Thank you.
Thank you very much. The debate will now be continued by Professor Bettner. He is Professor of Law and Society in Indonesia at Leiden University. Professor Bettner, a very warm welcome. Thank you very much for joining us at this ceremony today. The floor is yours.
Thank you, Mr. Chair. It's a pleasure to be here. Dear candidate, dear Manungal, first of all, I want to congratulate you on a wonderful dissertation, which for the first time really sets out the framework for addressing gross violations of human rights in such a clear and structured manner, which I think is a major achievement, and it's really important if we see what's happening in Indonesia today and the current lack of analysis of this important topic. Now, my question is about the subtitle of your thesis, which is the prospect of the settlement of the 1965-1966 events in Indonesia. Now, you talk about prospect, and there's, of course, a legal side to that, and you discussed that elaborately. As you just also mentioned in your summary, there are some problems, but no barrier, as you see. You mentioned, you give a couple of suggestions on how that barrier can be removed. However, I would say that it's much more a political matter, and Professor Alam already asked about that, but I would like you to take a look at that in a more broader way. When we look at the Netherlands and the crimes committed by the Dutch in Indonesia, and we think just of the war of decolonization, it's now 75 years ago, and only this year, for the first time, a film could be made about the atrocities committed by the Dutch. And I still remember, or not personally, but when this was addressed for the first time at the end of the 1960s, I mean, there was really an uproar of veterans, and it was complete. It ran completely out of hand. Now, when we think of Jan Pieterszoon Koen, who committed gross violations against human rights in 400 years ago, he still has his statue in Hoorn, and only today these matters start to be addressed in the Netherlands. So my question is actually, shouldn't be the title of your book be the absence of any prospect of a settlement of the 1965-1966 events in Indonesia? And I would like to hear from you what political developments should take place before we can see any addressing of the horrible events that happened in those years.
Thank you, honored Professor Adrian Bettner. It's also an honor for me to have you here to become the opposition of my dissertation. And thank you for the appreciations of my dissertations. You asked me about the subtitles of my dissertation, the prospects of the settlements. I admit that it has contains like political meanings behind that titles. Because if we only consider the title from a legal perspective, from a normative and legal perspective, positive laws, then it is quite clear that Indonesia have a legal framework to solve the problems. We have the constitutions that mandate all the state officials and the state to uphold human rights, to protect the Indonesian nation, the tumpah darah, the land and blood of Indonesia. And we have also in the constitutions a special chapter for about human rights in chapter 10. Also, in regards to gross violations of human rights, we have already in the year of 2000 law number 26 on human rights court. But because we cannot separate the existence, the presence of the law from the political background of the issuance or the promulgations of law. A year before, Indonesia was under international pressure to try military officers involved in the violence after the referendum in East Timor. There was a international discourse to bring those who are not those who were involved on perpetrators of crimes to international court. So Indonesia was under pressure, and in short, in the year of 2000, we have law number 26, 2000, in the year of 2000, that I mentioned also in my summary of dissertation. But the formulations of the laws, although it claims using the Rome Statute as the main reference, but in many provisions, it cannot be used to reach the top officials, like the definitions of widespread attack directly to the civilian populations. It was translated into serangan secara langsung to populasi sipil, or in other words, you have to be on the spot. You have to be in Indonesia you call it TKP, or in the place, so that you will be you can be convicted. Of course, this is not a defect. This is not only a defect, but it is a deliberate defect.
Sorry, can I briefly interrupt you, because this is very interesting what you're saying, but it's not really addressing what I really want to know. Let me put it another way: where is the political interest in Indonesia today to do something about 1965, 1966? Is there any political interest for any major political player?
If we talk about the political situation in Indonesia, I don't see that there is even a glimpse of light to that direction, because if we look at from the political perspective, many victims during at that time in 1965 to 78 were mostly nationalist or leftist. While if we see Indonesian political situation today, the government is now dominated by the nationalist factions, and there is no significant movement to that point. So I don't really see that. While in many ways, in other parts of political spheres, communism and PKI matters still being used by the political actors to gain political benefit or political goals. So like even when Joko Widodo was nominated by the Indonesian Democratic Party, his rivals accused him as a son or children or has communist or PKI blood, like that. And Joko Widodo refused that. Refused to. Joko Widodo tried to instead of promising to settle this problem, he was kind of no, I'm not PKI. I'm not that bad. Yeah. So even he didn't want to be associated with the victims. There was no sympathy to the victims, like that. So, and your question actually has a link or linkage with the question from under Professor Adam about the prospect or the likelihood.
Well, I really hope to discuss this further with you in Indonesia over a coffee. But thank you very much. This is a clear answer.
Thank you, Mr.
Thank you very much. The debate will now be continued by Professor Jansen. He is Professor of History of Law and Civil Law at our university. Professor Jansen, the floor is yours.
Thank you, Mr. Chairman. Dear candidate, you have written a beautiful book on a scientifically and politically interesting and controversial subject, a dark page in the recent history of Indonesia. It was with great curiosity that I read your thesis and I enjoyed studying it. I knew very little about this subject, and that greatly enhanced my pleasure in reading your book. Reading new things is nice at a time when you mainly have to spend your days with your wife, to whom I have been quite happily married for more than 30 years. She was happy for me to read such a beautiful book. I admire the way you conducted your research and the way you write about it. One of your research questions is whether the mechanism of a Truth and Reconciliation Commission, as recommended by the National Human Rights Commission, can be applied for the settlement of the 1965-1966 events. The Commission points to the added value of a non-judicial mechanism in order to fulfill the sense of justice for the victims and their families. Truth commissions can often make an important contribution, as you also write, to the restoration of relations in a particular country. Victims feel acknowledged because they are officially heard. Moreover, a report establishes the facts and identifies those responsible, while still making it possible to bring them to justice. In South Africa, for example, torture remained prosecutable. According to you, the Truth and Reconciliation Commission in Indonesia has a strong legal basis. The existence of a TRC is even a legal obligation that has to be fulfilled by the President. However, the Constitutional Court of Indonesia held on the 7th of December 2006 that the purpose of the TRC law to settle past abuse and to achieve reconciliation as formulated in Article 2 and 3 of the law are not possible to be achieved due to the lack of guarantee of legal certainty. The TRC law was therefore incompatible with the 1945 Constitution and had no binding legal force. Considering this decision, you write in your thesis that the establishment of a TRC will also be permanently impossible. To be honest, I'm a little confused by this decision of the Constitutional Court. Why fails the TRC law to give legal certainty to the perpetrators and victims to choose the TRC mechanism to settle their case? My first question for you is therefore, can you elaborate a little bit more the reasons why the Constitutional Court considers the TRC law not to be binding because it is contrary to the Constitution from the perspective of legal uncertainty? What exactly is this legal uncertainty? Article 2 states that the TRC is formed based on the principles of independency, free and non-partisan benefit, justice and honesty, openness, peace and national unity. The fact that the request for amnesty to the President can either be granted or refused by the President is, according to my humble opinion, not an obstacle to the principles of honesty, openness and national unity. Or should I see the decision of the Constitutional Court of Indonesia as politically motivated? As you write in your conclusion of Chapter 7, the suggestion of the Constitutional Court to achieve reconciliation through legal policies is no more than a suggestion, and I would add an opportunistic and uncommitted one. I have a second question for you. The Truth and Reconciliation Commission of South Africa, established in 1995, was a great success. It played an important role in South Africa's transition to a democratic state. The TRC can therefore serve as an example for other countries wishing to set up a TRC. Two important objectives of the South African TRC were to paint the fullest possible picture of gross human rights violations committed under apartheid and to restore the dignity of the victims. Both objectives fit in perfectly within the aims of the Truth and Reconciliation Commission in Indonesia. I'm aware that truth commissions have not been as successful in countries other than South Africa, such as the Philippines, where the commission's work was cut short halfway through. In Suriname, there was a talk of a truth commission for years, and a researcher was even appointed, but no results were ever published. But still, do you think the South African arrangement could be an example for a possible future arrangement in Indonesia? It is possible to draw inspiration for the Indonesian situation from the success of the South African Truth and Reconciliation Commission. I would very much like to wish it on Indonesia.
Thank you so very much, Honorable Professor Jansen. It's a very pleasure to see you again here. You have two questions for me. The first is about the RC law. You asked me to elaborate a little bit about the considerations of the Constitutional Court of Indonesia, why it was declared as contrary to the Constitution. And the second, you asked me about the practice of the RC in South Africa, which has one of the most successful story of the RC in the world. For the first question, I have elaborated in my dissertations about the follow-up of law number 26, year 2000, about the settlement of gross violations of human rights, past gross violations of human rights through truth commissions. But the law number 26 does not create or establish truth and reconciliation commissions. It states that it needs another law through the instrument of law to establish the Truth and Reconciliation Commissions. And 4 years later, we have Truth and Reconciliation law. However, in 2007, the Constitutional Court declared it as has no legal binding, because it believes that the article contradictory to the international principles. The considerations of the Constitutional Court is like, because if victims want to receive compensation, then he or she should give forgiveness to the perpetrators. So the right of the victims, the right to compensation is dependent to the willingness of the victims to give forgiveness. If you become a victim and then you refuse to forgive the perpetrators, then you will not be compensated by the state. That's what the Constitutional Court believes, that contradictory to the human rights and international principles. And also I also write in my dissertation that this actually doesn't mean that there is no possibility to settle through the problem of past gross violations of human rights through a TRC, because there is still a possibility to establish a new TRC law to settle the problems. The problem is that it's been like more than 15 years after the annulment of the TRC law by the Constitutional Court, and we still don't have a TRC law, and even until today. So from a legal perspective, I should say that there is no opportunity, there is no possibility, at least until today, when we meet that gross violations of human rights will be settled through a Truth and Reconciliation Commission. And I would like to address the second question about the RC in South Africa.
If you could address that question very briefly, please.
Yeah. The RC in Africa, it's a bit different if we compare with the 1965 to 66, because there, the victims has a strategic role in the TRC. Like Mandela even asked forgiveness when he became president to the victims. Even Mandela himself was victims of the apartheid regime. That's a bit different with the Indonesia, but no victims held the public officials that can influence the public policy regarding the past gross violations of human rights in the 1965-66 events. Thank you, Professor Jansen.
Thank you very much. The debate will now be continued by Professor Burema. He is a professor of rule of law at our university. Professor Burema, the floor is yours.
Thank you, Mr. Chairman. Esteemed candidate, let me start with complimenting you with this manuscript. It is impressive what you have described about the horrors of the 1965 and 66 events in Indonesia. And it is very important also for us in the Netherlands that you have opened up the report of the Komnas HAM of 2012. I think your brave thesis contains as one of its most important underlying propositions that the report of Komnas HAM is crying for an explanation from the side of the authorities. And if I'm well informed, there has never been some kind of really official denial from what has been stated by Komnas HAM, or I might be mistaken, and then that was one of my first very small questions. If I'm well informed, members of the armed forces have constantly refused to respond to the Commission's summons. So from their perspective, no answer will have come. But now for the real questions. In your thesis, you have discussed settlement through an ad hoc human rights tribunal as an option to resolve cases of these past serious crimes, as well as the establishment of a Truth and Reconciliation Commission. I won't go into that, but just state the obvious. As one of your conclusions is, well, I dare say there seems to be a lack of political will to act according to these lines. And that's why these findings do beg the question if it would be possible to change that political will piecemeal with legal means. And then I'm thinking of the ordinary criminal and civil law regimes of Indonesia. Let me elaborate a little bit on that, but that's where my question focuses on. Let me start with ordinary criminal law. Of course, the Indonesian Penal Code does not have provisions related to command responsibility, but nor does Law 26 of the Human Rights Court of 2000. My first question then is whether that really is obstructing an ordinary criminal prosecution of some, not all, of those individuals you mention on page 78, 79. In other words, would it be possible to start with the prosecution of some of the commanders who had effective control in the field as accomplices or as instigators of killings in Maumere, the enslavement in Mongkonglu, and the torture in the prison of Jalan Gandhi? That is according to ordinary criminal law. Starting with ordinary criminal procedures against some of the perpetrators of lesser value, one might find proof that makes it harder in the end to deny the role of higher placed individuals. Would it be possible to ask an Indonesian court of law to force the ordinary prosecutor to prosecute on this more customary path? And secondly, the more civil law road. As Professor Beidner already mentioned, in the Netherlands we have had a lack of historical memory about the revolutie of 1947 and 1949. That's changing rapidly. The Court of Appeal in The Hague, has held the state accountable, the Dutch state, accountable for torture in your War of Liberation in the village of Rabagade on Java in 1947, and the Court of First Instance did the same for killings in South Sulawesi. In both cases, only very small amounts for damages were paid to specific relatives of the victims, but nevertheless one might say that the recognition of what happened by courts of law has a value for its own sake, which could change the political law of politicians more involved. So I would like to ask you one very small question. Is there any official denial of what has happened? And second, how about these other solutions by using ordinary criminal or civil law? Thank you.
Thank you, honored Professor Buruma. Very happy to have you here. And you have two questions for me. First is about the law. And the second about the denial. If I'm not mistaken, you asked me. I would address the first about the law. That you think about using an ordinary criminal code, strafrecht, to bring this responsible to justice. The problem with the Indonesian Criminal Code is that it is, of course, only for ordinary crimes. This is it's not intended, not designed for gross violations of human rights. Yes, it contains provisions, articles about murders, tortures. Maybe we can use that. But it cannot be retroactively applied. This is different with law number 26, 2000, which clearly states that gross violations of human rights that occurred before the promulgations of this law, or law number 26 in the year 2000, can be applied to cases before the promulgations of law. While law number 1, year of 1946, if I'm not mistaken, about criminal code, does not contain the same provisions that allows for the retroactive applications of law. Even if it can be applied, then still it will be considered, or from a legal perspective, it will be considered or viewed as ordinary crime. So it is not crimes that is extraordinary or inhuman. It's savage and barbarous. That's all. That's what I can answer. And the second is about the you asked about
civil procedure.
Civil procedure in the case of Rawagede. Yeah, the compensation is now, there is a new development in Indonesia in regards to the gross violations of human rights. That we have Lembaga Perlindungan Saksi and Korban, or the institution for the protections of witnesses and victims. That you don't really have to bring a verdict from the court that declare that you are victims of human rights. But as long as you have you are victims of human rights, then you have the right to for compensations. And Rawagede was through court, through civil procedure. We have actually also similar stories about victims of 1965 filed a lawsuit against the government, and they got also compensations in the past. But that's more about individuals, not the groups of victims in a larger group as well.
Thank you very much. The debate will now be continued by Professor Fedorova. She is a professor of criminal law at our university. Professor Fedorova, the floor is yours.
Thank you. Dear candidate, congratulations on your impressive book. I have read your book with great interest and pleasure, and almost in one breath. In a fairly concise manner, you disclose to us one of the most terrifying moments in the history of mankind. Indeed, a very dark page for Indonesia and the international community as a whole, I would say. The impact of the 65-66 events is tremendous, and the inability of our civilized societies to heal the wound this kind of atrocities leave behind in a community makes one sad and angry at the same time. You refuse to take this inability as a status quo. Your dedication towards thinking through the ways to deal with the dark past in your country is inspiring. Your book is courageous and will hopefully leave a clear and positive mark on the road towards healing, closure, truth, and reconciliation. When reading your book, a memory of my visit to the extraordinary chambers in the courts of Cambodia, ECCC, took hold of me. I wrote my dissertation on the subject of fairness of the criminal process in international criminal proceedings. At that time, I had the chance to visit the mixed tribunal in Cambodia to follow the proceedings and to interview people who work there. Impressive as the step was towards seeking justice for crimes committed decades ago by the Khmer Rouge, the criticism that has followed ECCC's work cannot be ignored. The proceedings were too slow, the court too expensive. The bureaucracy and a fairly open corruption practices very damaging, and their ability to achieve the goals the tribunals were set out to achieve very much doubtful from the start. Has Cambodia benefited from the conviction of the two accused? Similar criticism has met other purely international criminal courts. In short, the procedures take too long, they are too expensive, and importantly, they do not lead to the needed reconciliation in the affected communities. It is even doubtful whether the truth that is established in the course of the proceedings before this tribunal is accepted as such. One striking example that was recently reported on by the Dutch national newspaper is the way former Serbians who are convicted by the ICTY and who have completed their sentence are received in Serbia when they return home. They are received as heroes, as examples of patriotic dedication to the country. The tension between Serbians, Bosnians, and Croats is still present, even almost 30 years after the conflict. It makes one wonder what the point is of prosecuting and punishing a couple of perpetrators who see themselves as scapegoats of the current regime. And more generally, do we give the criminal process too much credit in being able to achieve the goals beyond the establishment of individual guilt and punishment? Taking these examples of critiques on the effort to address mass atrocities through a criminal process into account, what are your thoughts on the necessity of a criminal process in Indonesia to settle past events? In your opinion, is the criminal prosecution a preferred way of dealing with gross human rights violations? Should we not better direct our efforts on presenting the truth to the public, to which actually the preliminary investigation by the National Human Rights Commission already greatly contributes, by resetting our collective memory, by rewriting our history books, instead of installing criminal prosecutions? I look forward to your thoughts on this. Thank you.
Thank you so very much. Thank you so very much, Honorable Pelodova. You asked me about which one is more preferred court mechanism or truth mechanism. Well, in the case of 1965-66, it's been more than 50 years after the case, after the events, if we count until today. So many people say that what is the most important today is that victims and their families got compensations, rehabilitations, to be clean from their names, clean from the stigma, negative stigma that is still exists until today. Of course, court mechanism is also important, but some also feel skeptic because evidences and even the perpetrators, many of them has gone or died. Even Suharto, one of the most responsible person in the crimes, is now passed away. So that's what we have now. That maybe Indonesia should look this problem with a clear way.
Hora est.
The defense is hereby concluded, and I once again give the floor to the candidate.
Having defended my doctoral thesis to the best of my ability, I would like to thank the rector, my supervisor, and co-supervisor, as well as those who have honored this ceremony.
The doctoral examination board now retreats for its deliberations. On behalf of the Council of Deans of Radboud University in Nijmegen, we have decided to award you the degree of Doctor. I invite Professor Van Kempen to fulfill the task assigned to him.
Thank you, Rector. In the name of the Lord, with the power entrusted by law to the Council of Deans, I hereby confer upon you Manungal Kusuma Wardaya, born in Surakarta, the title of Doctor from Radboud University, Nijmegen, to which are attached all the associated legal and customary rights and duties with respect to academia and society. Normally, I would give you the diploma in real life, but I'm proud to show it to you. Here it is.
Thank you.
It is signed, so it is official now.
Thank you so very much.
And this is usually where there is a loud applause, but we'll have to make up for that at some other occasion. I would like to invite the supervisor, Professor van Kempen, and the co-supervisor, Dr. Bakker, to now address the laudatio.
Dr. Wadaya, very learned Manungal, dear Angie, it is difficult to express how deeply happy I am for you and for the wonderful and well-deserved position you have just obtained. You have acquired a PhD in law and are now a Doctor of Laws. The basis for this is an important book on an important topic. Congratulations to you and to your family. Early 2010, you contacted the faculty here in Nijmegen and sent us a research proposal and your CV. This was forwarded to me, and from then on, we exchanged many emails to discuss your research project. I asked Lawrence Bakker to come aboard, and he said yes. With the confirmation that Lawrence and I would be your supervisors, you applied for an Indonesian scholarship to do your PhD research at Radboud University, Faculty of Law. And the scholarship was granted. So on 20 December 2011, you arrived in the Netherlands. That again underscored that you are a brave person. The weather was bad, with a lot of rain. Not the warm showers of Indonesia, but very cold Dutch drops and drizzle. Nevertheless, it was a happy moment. This is when you really started with your research and when we came to see each other many days of the week. You stayed with us in Nijmegen for 4 full years and then went back home to continue your position as lecturer at Universitas Jenderal Sudirman on Java, and that was in 2016. To use an understatement, it was certainly not always easy for you, being away from your wife and children and beautiful Indonesia for so long a time. As a result, you succeeded admirably well, because you had an enormous energy and you were unprecedentedly potent to continue on. Not only did the dissertation develop line by line, you immediately also became a very well-liked and much appreciated member of the Department of Criminal Law and Criminology. You were a regular at the department's annual outings and similar convivial meetings. You saw how other members of the department defended their PhDs. And now you have done it yourself. A magnificent moment indeed. The Department of Criminal Law and Criminology is proud of you. As I said, your dissertation is an important book on an important topic. The 1965-66 events in Indonesia entail that which is humanely unthinkable. But as the Hungarian-American historian John Lukács remarked, the trouble with what is unthinkable is that at times it must be thought about. That is exactly what you have done. To recognize and analyze the past is usually also of great importance to the future. That indisputably also applies in this case, in the case of your dissertation. As you yourself express in your dissertation, from a legal perspective, the massive and systematic human rights violations in the form of crimes against humanity that erupted during the 1965-66 events are a phenomenon that could happen again in Indonesia. Talking about one's country's dark past is always difficult, as is sometimes also illustrated in the Netherlands, and often courageous. But it must be done, and you have succeeded in doing it. With that, your dissertation is also of real societal importance. To quote Elie Wiesel, a survivor of the Holocaust, for the dead and the living, we must bear witness. Dear Manungal, from the very start till this moment, it has been a true delight to be involved in your research project, in your PhD project. The project has come to an end, but will remain a basis for your future as an academic and probably also personally. The project has ended, but our relationship has not. And I immensely look forward to the moment when you, Lawrence, and I will sit together and cheer your dissertation, cheer you, and cheer life itself. Thank you.
Mas Manungal yang terhormat, selamat ya, congratulations. I will not repeat what Piet Hein said. He spoke at length on your academic path, on doing your research, writing your thesis, and obtaining the degree of doctor. But as you know, I'm actually kind of wearing two hats while being here. We are here in a setting of the Faculty of Law, and I know some things about law. But actually, in real life, of course, I'm an anthropologist, which is actually a bit different from being a lawyer. And I like to point out a few elements of what you have just done in a more central, more social context. You just defended your PhD thesis, with which you obtained the degree of doctor. Does that change you as a person? Maybe somewhat. I hope that you will sleep very well tonight. And I also hope that you will feel happy and proud of yourself. Does it change your position in society? Well, yes, it does. You've moved on from being Manungal, who works at a university as a lecturer, to now being the Manungal, or the Dr. Wardaya, who obtained his PhD overseas in the Netherlands. You changed in that sense. If it is in status, if it is in reputation, that is for you to experience. But I can say, from visiting you in Indonesia, that I think it will make a difference. I imagine that while your PhD was not defended as yet, there would be colleagues coming up to you asking, sudah selesai? Kapan selesai? Like, are you done yet? When will this be done? Why are you not finished yet? More or less those kind of questions. And those tend to be somewhat annoying, worrying, when you are the person who they're being asked to. Well, by now, of course, you can say, right, I've left that phase of limbo, sudah selesai, benar. It's finished, I'm done. In that context, there is a change in your position within your field of work, within your family, amongst your colleagues, and that is something that is quite important. And with that, I would like to congratulate you. But there's another thing I like to thank you for, basically, and that is for showing me a different way of looking at the Netherlands. And that is because while you were in Nijmegen and working hard on your thesis, sometimes in between, you wrote these interesting columns in Indonesian on your life in the Netherlands, which you published here and there on the website and in various media, and in which you wrote on what you saw in Dutch culture, Dutch society, in the university every once in a while, and how you experienced that as an outsider. And I also should thank you for the introduction you gave me into 1960s, 1970s Indonesian pop music, which was not a field that I was at home in. But one of the things that came with doing a PhD for you was, besides writing your research down and really delving into that, delving into the European pop music scene. I know that you know Nijmegen very well for the Radboud University, but I also know that you know it very well for the Goffertstadion and the concerts that were being held there, in which you visited every once in a while. And while discussing music, of course, you gave me a whole new impression of what music meant in an Indonesian context. I also look forward, as Piet Hein said, to discussing this, hopefully over some very nice Indonesian coffee while sitting next to a lake in Java near to your home. But let's see what the future has in store for us. Again, congratulations.
Okay.
Thank you very much. Dear Dr. Wadaya, it is my great pleasure to congratulate you and your family most warmly on behalf of the Council of Deans of Radboud University. In your thesis, you've addressed a dark page in Indonesian history, but the successful defense of your thesis today moves towards a very bright future for you. It goes without saying that we would have very much liked to be able to congratulate you here in Nijmegen in person today. That is particularly true for the members of the Doctoral Examination Board that you've spent the last hour debating with on your thesis, and it is my great pleasure to very briefly give each of them the opportunity, now that we are still connected via Zoom, to congratulate you. And may I first give the floor to Professor Adam. Please unmute your microphone, Professor Adam.
Ya, selamat untuk Manunggal Wardaya. Terima kasih.
Thank you, Pak Adam. Terima kasih.
Professor Bettner.
Secara singkat ya, saya senang sekali memang Manunggal dapat gelar doktor sekarang luar biasa, dan saya memang look forward kepada pertemuan lagi di Indonesia. Ya, tapi senang sekali saya, memang itu luar biasa dan bagus.
Very impressive. Professor Jansen.
Young Dr. Wadaya, my deepest and warmest congratulations with this beautiful result. I wish you a beautiful day, full of joy in Indonesia.
Professor Budema.
Thank you, Prof. Jansen.
Dear young doctor, I can't congratulate you in Indonesian, and I would really have liked to do that. So maybe I just stick to all the Dutch, because you have lived here for 4 years, and well, van harte gefeliciteerd. Congratulations with your wonderful success. Your defense was wonderful, and I hope you will enjoy this day for many years to come.
Dank u wel, Mr. Buruma.
Your Dutch is indeed excellent. Professor Federova.
Dear Dr. Diangi, it's been a long time that we've seen each other, and I'm really happy to see you here today. You've done a wonderful job on your book and your defense, and I really hope to see you one day again. Let's hope that. Bye.
Now that we're at it, Professor van Kempen requested just 2 seconds of our time.
Yeah. Well, Manungal, I think through you, there will always be some Indonesia in us. And I think also through us, there will also be some Nijmegen, the Netherlands, and Europe in you. And I bought a present which I will send to you. I would normally have given it to you now, but I will send it to you, and it will explain better what I just said. Congratulations again.
Thank you. We have now come to the conclusion of this ceremony, and I ask those present here to please rise. Gratias tibi agimus, omnipotens Deus, pro omnibus beneficiis tuis, qui vivis et regnas per omnia saecula saeculorum.
Goodbye to all of you.
Sorry.